Hey, good evening, everyone. My name is Jeannie Evans. Okay, so I am the president of the Harvard Law Society of Illinois, and I'm here to welcome you on behalf of not just the Harvard Law Society, but also Harvard Club of Chicago, and also, and I want to make sure I say this right, the Harvard Alumni for Global Women's Empowerment. So I want to welcome everyone in the room, and I also want to welcome our remote participants. So we have members of Harvard Alumni for Global Women's Empowerment who are joining us by technology, which has been provided by Latham & Watkins. So we also thank Latham & Watkins for hosting and for providing that access. So now, if you can't hear me, please give me a little wave so I know I've gotten too far from the mic. So thanks so much for coming. As you know, we're here to talk about the legal issues surrounding sexual assault on campus. There's often a focus on the very serious and tragic circumstances for the victims and accusers, and we're going to focus a little more this evening on some of the serious circumstances for the accused and the due process concerns when a student is accused of a serious violent criminal offense. So we want to talk about what parents can do, what teachers can do, what universities can do to protect students from having their educations derailed by sexual assault allegations, but also to think about the concerns of the accusers. So I would like to proceed by introducing our panelists. We have a very interesting group. We have Justin Dillon, who is a partner at Kaiser Dillon in Washington, D.C. He specializes in school discipline and white-collar criminal defense cases. He's represented students at more than 50 schools nationwide. And before entering private practice, he was a prosecutor with the Department of Justice. He was a trial attorney with the Office of Civil Rights at the Department of Justice. He also clerked for Judge Ebel on the 10th Circuit. He graduated from Duke University and from Harvard Law School. So thanks for being with us, Justin. We also have Hanna Stotland, who was the past president of the Harvard Law Society of Illinois, so I know her well. Hanna has an interesting background. She flunked out of high school and got her GED, and then went on to attend and graduate from Harvard College and from Harvard Law School. She clerked for Judge Bucklow in the Northern District of Illinois and Judge Williams on the 7th Circuit. She's now an admissions consultant, and so she specializes her practice on working with students who want to continue their education and their higher education degrees after facing mental illness, facing school discipline, addiction, and other criminal charges. So she's worked with dozens of students accused of sexual misconduct under Title IX, as well as with students who have survived sexual assault. Okay, and our third panelist, Tanya Jachimiak, is currently director of the Title IX office at Wake Forest University in Winston-Salem, North Carolina. In that role, she's responsible for the development and implementation of compliance programs for Title IX, of the Education Amendments of 1972, the Violence Against Women Act of 1994, Campus Sexual Violence Elimination Act, Title VII of the Civil Rights Act of 1964, Section 504 of the Rehabilitation Act of 1973, the Americans with Disability Act, and related laws and regulations throughout the university. So she's working with all levels of university administration to implement programs, just to create an environment of support, of like a safe and supportive and respectful environment for working and living for students and all members of the campus community. She has 16 years working with these issues, counseling and representing employees and employers. So without further ado, I will turn it over to our panelists, and we also have as our moderator Julie Palmer, who can come up as I need. Okay, thank you.
All right, super. Welcome, everyone. I'm Hanna. This is Justin. This is Tanya. We started out with intros, which Jeannie has already done a great job with, covering all the core issues that we wanted to address, except for perhaps for the fact that Tanya has deep roots here in the city of Chicago and in the legal community here. Justin and I have an ongoing relationship which prompted the creation of this program, which we've now sort of taken on the road. This is our third presentation of it. We were so how many law school grads in the room? Okay, so about half. So we were 1L section mates, so we had all of our classes together, and he was one of the more conservative folks in our section, and I was a very loud liberal feminist, as I still am, and you can imagine how that went for the whole year of law school with both of us in the same section. We later became co-teaching assistants in constitutional law under Larry Tribe, which was, again, a very interesting experience with these 5 TAs who were kind of all over the philosophical spectrum, and I think both of us attribute a lot of the value that we got from our Harvard Law educations to the fights we had with each other and with other smart, well-informed, intellectually honest people who disagreed with us about everything. And yet, this issue of Title IX and Title IX enforcement is creating a lot of strange bedfellows, like me and Justin, who are now more or less on the same side. And we discovered just a couple of years ago that we had both found ourselves in practicing in the Title IX area. I'm not even a lawyer anymore. I'm an admissions consultant. And I read in the Wall Street Journal where he was quoted about a student he was representing as an attorney, and figured out the left-right divide just doesn't work very well here. It doesn't predict how people will feel about Title IX policies, and there's speaking on my side of the spectrum, there are deep divides among feminists about what the problems are here and how we should be addressing them.
No, I think that's right. Yeah.
So here are some ground rules, if any of you want to chime in on these, but some of this we wish didn't have to be said, but it does. Rape is real. Nothing that any of us say should ever be construed to contradict that. Rape is never the victim's fault. And we want to recognize that, first of all, we want to let you all know that this may be an explicit conversation today. If we get into kind of case studies in response to questions, it may be necessary to talk about certain sexual acts that were disputed. But also, this is just an incendiary and emotional topic for everybody. I want to recognize we may have assault survivors in the room or parents of assault survivors. We may have people who were or are close to people who feel they were falsely accused. And we really want to welcome all civilly expressed viewpoints with a recognition that this issue cuts deep in a lot of families. So this is kind of our introduction. This is a young man. I got this from the website of the University of Minnesota. This is a young man trying to make the world a better place. And I really non-cynically believe that. This is the University of Minnesota's anti-sexual assault program, which is called No Gray. Either the sex is okay or else it's rape and there's no gray, and we have this nice bright line. And my thesis, and I think is shared by my co-panelists, is yes, gray. Yes, gray. We are talking about human communication. We're talking about young people. We're talking about sex. We're talking about drugs and alcohol, and we're talking about memory. Yes, gray.
I think that's right. I think it's interesting, right? A lot of times the cases that you see reported, so often are far more black and white. I mean, take this as an example, actually. An op in the Washington Post about the University of Minnesota football team case a few weeks ago. That sort of horrifies people who do what I do. And sort of what we talked about in the op-ed was that this is the kind of case that gets all the press. And it was a horrific case. And now I don't know
This is a case with 15 football players with one woman in their room.
10 to 15. It was
that they had just met.
Terrible. And I got about halfway through I think something like 80-page investigative report, which again may or may not have been done fairly, but I've seen a lot of them and it looked like a pretty good report. It's horrifying. And I think the problem is that there's often people often legislate or act on the worst case, but not the mine run of cases. And I mean, again, my firm's done these cases, and now we're 50 schools. We've represented probably, 80 plus students just in the last few years. And I've never seen a case like that. I can absolutely guarantee you that is an outlier. The fact is that, and maybe it's who hires me, right? Like I get hired. We do criminal work, but I don't really get hired in cases that are just go to the criminal system. I get hired in the gray cases that are happen on campus. In fact, literally no client that I've ever represented has ever been criminally charged. There's been police that poked around. We don't talk to the police, but they've never been criminally charged. Everything I get hired to do is yes, gray all the way. And I think, unfortunately, that is a narrative that gets swallowed by the more extreme cases that capture the headlines. Because the problem is the gray cases, they never make the papers. Certainly the falsely accused student doesn't want to make the papers, because you know what you do if you raise your hand and if you say I'm a falsely accused rapist, everybody just remembers accused rapist. So those don't make the headlines because people tend to elide the word falsely.
Anything to add?
Well, I just wanted to say that with regard to the idea of false allegations, many times when students come forward, there may have been something that happened. There may have been a disagreement, misunderstanding that may not rise to the level of being a sexual assault as defined by particular policy or criminal law. And for me, that's what I mean by being in a gray area. Not to say that all cases are gray. And again, most of the cases are acquaintance. It's not the man jumping out of the bushes and attacking a woman. Now, those do happen as well, and I've seen those. But most of the time, it's acquaintance, and it's also not. Women aren't the only victims as well. So I want to keep that in mind too. That all genders are affected by sexual assault and may be victims or survivors of sexual assault.
I think that's right. And I'll also say this. I don't believe that the people who and I'll probably end up devolving into gendered language here, because Tanya's exactly right, but I think statistically the vast majority of respondents are male, at least that I've seen. I think a lot of times I can count on probably one hand the number of cases where I thought the accuser was making it up. I believe that most of the time the accuser sincerely believes what they're saying. They're not lying. They're not saying something to be vengeful or something like that. It's just that for various reasons that we could go into at some point, they've convinced themselves of something. So I think they are very, very gray. It's not this narrative that it's like, oh, there's all these false accusers out there running around to ruin people's lives. I don't think that's it. I think it's a complicated thing.
Complicated, yes. Exactly. Yeah.
Complicated or gray. And just to piggyback on your point about as far as students lying, that's not how I think of it. And I think many of us assume if you have the only two witnesses who were there and they're telling wildly different stories, that someone's telling the truth and someone's lying. And I find that that's rarely the case.
Yeah, I agree with that.
They're both doing their best. And, if we had a video camera there, we might see something that doesn't match either story. So, lawyers. I'm a lawyer by training, but these are lawyers by practice. So please tell us about Title IX. What is it?
Yeah, we'll keep this simple so you don't go to sleep. Title IX, we got the language up there. It basically prohibits sex discrimination in higher education for any school that receives federal funding. And traditionally, where we first heard of Title IX was when, wrestling programs and started to disappear in favor of, girls field hockey. And that was sort of the first controversial thing in Title IX. I think it's since evolved, and now the way the government interprets it, and I think rightly so in broad strokes, is that it is in fact sex discrimination to have a campus environment that has, let's say, sexual assault can interfere with someone's ability to experience their education, and that is often a gendered thing, and so it's essentially it is the sort of, you might have heard of Title VII, which is sort of you can't discriminate in employment. Title IX is you can't do it at school. Tanya, you do a lot. You're more of a pure Title IX lawyer than I am. Did I get that roughly right?
You did. Exactly. And the other thing I also want to mention too with regard to Title IX is that it's not just a sexual assault, but it's it could be anything from stalking, which could fall under sexual harassment. So it's a pretty wide definition.
And then we come to the Dear Colleague letter. I believe the French. Speaking of wide, I believe the French phrase I'm looking for is bête noire. Is that what it is? It's the bane of my existence, but also probably the foundation of my practice. So in 2011, the Office for Civil Rights in the Education Department promulgated a Dear Colleague letter, and that's basically a letter that it's Dear Colleague it's a darling way to put it. It's just like dear every school in the country. Here are some things that you need to do. So it may start with dear, but it is nothing less than a mandate by its own language. And it essentially imposed a wide variety of new requirements on every college in the country that receives federal funding, which is all of them except I think Hillsdale and like maybe one or two other ones.
Yeshivas.
Okay, and some yeshivas, but the vast majority. It required certain things that had never been required before, and frankly, the Education Department as a whole had never thought were required before by Title IX. And the most prominent among those is it imposed the burden of proof that literally every school in the country is required to follow, regardless of its size, regardless of its resources, its religious background, whatever it is. And that is preponderance of the evidence, which is the lowest standard to basically prove anything in the law. It's 50.1%. Before that, some schools, Princeton, UVA, and others used clear and convincing evidence, which typically people would say is somewhere between 65 and 75%. It also did things like bar cross-examination. So the sides are no longer allowed to directly question each other. And it imposed a host of new requirements. If schools violate these the rules laid out in the Dear Colleague letter, a couple of different things can happen, one likely and one less likely. The likely one is that the schools will be subjected to a very, very expensive investigation. I've already met one white-collar lawyer in the room, and as I'm sure she could tell you, and anybody who does this work could tell you, having the government write you a letter that says, hey, we think you did something wrong, can you send us a bunch of documents going back 10 years, is really, really expensive and time-consuming and resource-intensive. And it's a real strain on a lot of schools to comply with that. So that's the first leverage they have, is just the mere fact of sending you a letter. The second one is they could actually pull your federal funding. Now, Catherine Lamon, who's just the outgoing head of the Office for Civil Rights, has said, oh, we really mean it. We would pull people's federal funding. And I think colleges believe that. I don't really believe that. I believe that, like, for example, do you really think that Chuck Schumer would ever allow some flunky in OCR to take away Columbia's federal funding, no matter what Columbia is alleged to have done? No way, no how. But it still scares the bejesus out of universities, and I think they have acted accordingly. And my firm is actually currently has a pending lawsuit against the Education Department for having illegally promulgated this letter for unbelievably boring administrative law reasons that I will not burden you with. But you can feel free to email me if you have trouble sleeping tonight.
Right. And it's also like the publicity, right? So a university we don't want it in the paper that the OCR is even threatening to pull federal funding. And so it's a very big stick but they don't necessarily use it. But a lot of it has to do with pressure from the public, publicity, donors, alums, that sort of thing. And
this current iteration of the Office for Civil Rights, I believe, was the first time they publicized the list. They sort of saw value in shaming, which, it's arguably there's merit in that, but it's hard for schools.
So I have a lot of folks hear what I do and say, oh, the pendulum is swung too far in the other direction. And there's some truth to that, but I think it's way too simple a metaphor because there are thousands of different pendula swinging in different directions at different schools and in different cases at the same schools. The cases in most places don't have precedential value. And so you could have cases that come out wildly differently, even on similar facts at the same institution. And I would point out the more things change, the more they stay the same. I mean, I think schools rightly are concerned, like any other institutions, about what's good for their institution. And what we see is pendulum swing in the sense that some institutions may see in some cases that it's better for them that more cases come out for side A rather than side B, or that they are perceived as more friendly to side B. That I don't really see that as a shift. It is not a shift to neutral truth seeking, which is what I think everybody just about wants in these kinds of tribunals. And the pattern, from a feminist perspective, the multi-century pattern in the U.S. and around the world of institutions and universities in particular just ignoring or sweeping under the rug any accusations by women that there were some kind of mistreatment on campus, that doesn't go away overnight. That's still out there, and all the people who, feel that way still have their jobs. And so I'm pointing to Kansas State case where two young women who were students at Kansas State claimed that they were raped by the same fellow Kansas State student at an off-campus fraternity house. It was a recognized student organization, but not KSU property. And KSU was like, well, we're not even investigating that. That's just none of our business if one of your fellow students raped you, down the road. They're suing. Kansas State got lots of bad press. Meanwhile, the criminal case against the accused in that matter is proceeding through the Kansas State courts. But I just mentioned that case to illustrate there isn't one giant pendulum that's gone in favor of accusers and against accused. There's still lots of inertia. There's still lots of sexism in my judgment. It can't be fixed by pushing a bad system in another direction. We need a better process.
Mm-hmm. I would absolutely agree. I mean, it's really, from my standpoint, it's really important. And what my goal is to be objective, to be that neutral fact finder when I go into any of these cases, and to ensure that not only is the complainant or the accuser supported and that they have the proper confidential resources so they could heal, but also that the accused party, who also may be traumatized, may or may not be traumatized, that they have the best and appropriate support as well, and to make sure that there's due process along the entire way, so that, again, there's no assumptions, and that there's processes in place so that we all have certain implicit biases, but those implicit biases, that there's a process in place for checks and balances. And that's really what it comes down to, is a lot of checks and balances are really important.
I get a lot of questions about how many campus sexual assaults there are. There's a huge debate about, is it 1 in 4? Is it 1 in 6? I think for our purposes, it doesn't matter very much because the number is too many. And unless you are a public health researcher who needs to measure the effectiveness of an intervention, too many is a real good number to work from, frankly. We have a lot of college and university students in this country, well over 20 million. So, yeah. So I want to introduce some problems that we have in the current system that I think that implicate due process problems. I've got here a pack of gum and a Rolls Royce. And my idea here is that if you steal one of these or the other, it's stealing, it's wrong in both cases, but we don't usually use the word stealing. We would say either shoplifting or we would say grand theft auto. And those are hugely different. They have huge different implications for the consequences that the perpetrator would have. The rights of the perpetrator to an attorney would only kick in here and not with the gum. Certainly having one or the other on your permanent record would have a colossal difference on your future, as it should. And right now, many schools are just going to say either sexual assault or sexual misconduct on the permanent record and on the transcript of the student who then wants to transfer and or apply to graduate school. And my students, some of them were accused and found responsible of grabbing somebody's booty on the dance floor, and some of them were accused of rape. And they may both be stealing, but it's not the same thing, and it's a real problem for for the fairness of the current process.
And Tanya has a great story about that.
Right. So I saw in this, it was the separate, different institution, and on the potential student's transcript, it it basically stated that this individual had violated the sexual misconduct policy, and they had the full name of the policy, which included violence against women. And so from the transcript, it appeared as though this person was violent towards women or towards other students. And so when I received the appropriate waivers and spoke with this institution, I found out that there really was no violence involved at all, and that it really had to do with electronic communication, that there was no even face-to-face time between these two individuals, but that it was this institution's practice just to put the name of the policy on the transcript. And it was really unfair. Now, if there was truly violence, if there was stealing of the car versus a pack of gum, I mean, that would absolutely, it would make sense, but stealing a pack of gum is very different.
And think about the impact. I mean, for those of you who are involved in hiring, right, whether, or in admissions, right, if you see, it's hard to sort of unsee the pink elephant of sexual assault violence or sexual misconduct violence once you've seen that. And if that's the label that winds up on your transcript or something like that, it can have a life-changing impact. And honestly, it's great that Tanya sort of looked under the hood, but how many people would? How many of you as employers, if you saw that, how many people, you lawyers at law firms, for God's sakes, right? I mean, doing hiring. No, like we're in this lovely law firm right now. Do you think for one second they're going to see that on a transcript? Like, let's look into that. No, they're going to go to the 1,000 other people who want that job and don't have that on their transcript, and not even bother.
And in my practice, I have a number of felons, non-sexual felons, and in general, those cases are much, much easier for me to find appropriate next stage education for those students who had the felony DUI, felony breaking and entering, versus someone who was found by 51% likelihood to have committed this sexual touching without affirmative consent. It's much, much harder. They're the toughest group of work, they're a delight to work with. They're the toughest group of students to place.
And one more thing on this point, and then I'll shut up about this point. A lot of you guys have heard of ban the box laws. That's big in DC where I live, right? You're not allowed to ask somebody on an employment application if they've had a criminal history. Think about overlapping Venn diagrams. People who believe in ban the box laws because your history of criminal act, after being adjudicated in full due process, should not follow you around for the rest of your life. How much does that Venn diagram overlap with people who think that you should have transcript notations for sexual assault? I mean, in my experience, it's a pretty complete overlap, and I find it hard to find a consistency there, except as if you want to be outcome oriented.
So here's another question I get from lots and lots of parents. So where should I send my student to avoid this problem? Well, we've got a huge problem in evaluating. Schools are required by federal law to report publicly how many rapes and other kinds of crimes are reported to them. In 2014, which is the most recent year with complete data, the university in America with the highest absolute number of reported rapes was Brown University. Brown University has about 6,500 undergrads. I want to remind you of places like UCF that have over 50,000 undergrads living on campus. I do not personally believe that Brown is the rape capital of American education. I don't. Now,
That'd be a hell of a motto, though.
Yes. And if you measure rape reports by capita, and this statistic is just rape, not booty grabbing. If you go by capita, looking at smaller schools and not just by absolute number of rapes, here's your top three: Reed, Wesleyan, and Swarthmore.
And what do three of those four colleges have in common? Reed, Wesleyan, and Brown. Honestly, and I say this, again, this is when I'm the conservative, they are on the far left of the political spectrum and known to be that.
They are.
And I think, is that because there's just a lot more rape-inclined people there? No. I think it goes to sort of a campus culture that, in my opinion, I've seen this in a lot of schools, including Wesleyan, which you should never send your children to. I think encourages a culture that has people transform things they regret into something like rape, and it sort of suffuses on this whole the no gray idea takes hold there at schools like that. And I think it's no coincidence that 3 of the 4 schools are very, very clearly on that end of the spectrum. And look, Swarthmore is probably 2, but I think not as clearly as those. I bet you Oberlin gets up there in the next couple of years.
At the other end of the spectrum, there are many giant state universities that report 0 or 3 when they have tens of thousands of undergrads living on campus. And I think that has a lot to do with what is the message at that school about whether it's worth it to talk to anybody, whether women have any voice at all, or whether gay men have any voice at all, and whether it's a huge waste of time to even let the school know that this happened to you so the reported numbers are just really crummy ways of distinguishing how much sexual violence is happening on campus. They're worse than useless.
Right, I would absolutely agree, and also it's how how the rape is defined under the Clery Act is very different from what policies or the state laws may define it. And also the reports are only those occurrences on campus. So it has to be a Clery crime that happened on campus. So if you have an institution where most of the students are living off campus, again, to your point, there may be many more sexual assaults or rapes that are occurring that aren't reported. And so therefore they're not going to reflect on the Clery report. So they're not very helpful, and I'm always very skeptical when I see 0 on a Clery report. Very skeptical.
Right. So this is a kind of a theoretical question, especially for kind of those of us, including myself, who consider ourselves social justice warriors. Why are we hearing so much more about rapes on campus than we are about rape of college-age women off campus? Almost all of the data show that women 18 to 21 who are not in school are at greater risk. And I think there are race and class reasons why the women who are in colleges, especially residential colleges, are getting a whole lot of attention and concern from senators and so on, and people, getting raped by a coworker at McDonald's are not. Catch-22.
So this is one of the hardest things in these cases for families to figure out is, do you talk or not? Let's say you've been accused of sexual assault, and again, let's say what I would say was the mine run of cases where it's not force, it's 2 people drinking, and sort of that kind of ambiguity. There are some lawyers, and you kind of have to pick your poison, I guess, is the bottom line. Some lawyers, and a lot of people who do just criminal defense and don't do that many of these cases will say you can't talk because you know that anything you say to the school will go to the police if the police move forward. And that is true. It will. At my firm, as I said, we've represented a lot of people, and we've literally never had a client criminally charged. And I think you have to pick your poison. And I tell clients, after I look at the facts, I tell clients, look, in my experience, if you don't talk, you have a much, much higher likelihood of getting suspended or expelled or found responsible. And if you do talk, yes, that increases in some way, I suppose, your vulnerability to criminal prosecution. But I say this I was a federal prosecutor. I was in the civil rights division, but I was also a good old fashioned, put him in jail federal prosecutor for 5.5 years. So I used to do this part. I think it is. Ultimately, I think the poison that I would pick would be going on campus and participating. We've literally never had a client that, every client we've had always participates. And the police come sniffing around. We don't let them talk to the police. But I think it's a really hard decision for families. And honestly, we get hired a lot where they had what I would call the local criminal guy who said, yeah, don't talk, just shut up. And they can't prove a thing. It's he said, she said. You're going to lose, in my experience, 9 times out of 10. And I often have to try to clean up the the mess when that happens, and it can sometimes be hard to clean up. We've actually, for those of you who would like further reading, my partner Matt and I wrote a book about, like an ebook, for families that can't afford lawyers. And we talk about this for people who are trying to struggle through this, because it's terrifying to families, especially families with limited means who can't afford, fancy lawyers or even unfancy lawyers. But it is very, very hard to figure out, do you talk and potentially hurt yourself if it goes criminal, or do you not talk and almost certainly get suspended or expelled? And it's a really hard decision. Again, we go one way really in every case, and I have yet to see the case we wouldn't do that in.
I do have a number of clients who were under criminal investigation at the same time as a school investigation, and the criminal charges are generally dropped, but that's a scary thing. During the pendency of that criminal investigation, to often go against your lawyer's advice and defend yourself in the school proceeding, and all your words could be used against you.
Right, and the U.S. Department of Education requires universities to simultaneously conduct their investigations and require that universities complete their investigations within 60 days of having knowledge of a report of sexual assault. And it could be very difficult because on one hand, we don't want to interfere with the criminal investigation, and for reasons that Hanna and Justin just mentioned, the accused parties, they have their Fifth Amendment rights not to speak, and things they could say could be used against them. So it's really important for universities to recognize the risk, and to try to balance. Again, it's all about balancing the rights of the victim, but also the rights of the accused party. So anyway, I just want to say that I recommend that accused parties do have attorneys. I think they could be very helpful in many cases, but universities also need to make sure that they support both sides.
And just to note, we are going to have a lengthy question and answer period coming up, but I'll point out that a lot of students can't afford attorneys, and a few universities, notably Stanford, have stepped up to say, well, we're going to provide attorneys for both accuser and accused, which is going to make their process a lot more truth-seeking, and which pretty much only Stanford can afford to do.
Right.
This is just for the amateur and perhaps professional law professors out there who like thinking about the underlying theory. This is just not a very practical question, because Title IX is the tool that we have to deal with sexual assault on campus, but it is quite clearly written about sex discrimination, and when we see same-sex cases, I think the theoretical underpinning there, I haven't found the law review article yet, but I'm sure someone's going to write it. But it's an interesting question for those who enjoy this kind of theoretical problem. So what would be better? I think trained professionals, and some schools have them and some don't.
Yeah, it's not. I mean, this is meant to show it's not brain surgery, if that's a brain being operated on. But I think having sometimes you get these investigators who are incredibly inexperienced, no legal background, no investigative background, and I mean, literally, one of the last cases I had, the investigator before she started doing this work was I think it was like a director of like campus housing or campus recreation. I mean, just great. You're as qualified to rebuild a carburetor. But that happens so often. I think
they would never put her in the campus nurse's office. So
I think it can
say, well, that's a campus function, so now you can give shots and diagnose mono. After a weekend training, they would never do that.
Exactly. But Tanya has I think has had some unique insight. And I say this as Tanya is someone who is highly trained and highly able to do this because of her background.
Well, I think, I think it's really important, and I've seen this where there's a decentralized process where individuals, either in human resources or, who could be, I think you may have mentioned like a cafeteria worker at some point was making decisions. I think that, so for those
they called it giving the staff a voice.
Right, and it's not. I don't blame those individuals. I mean, it's the employers, the universities who are asking individuals who are asking individuals to take on this role. And so I don't fault Title IX coordinators that I've met, many of whom don't have a legal background, may have only gone to one training, and they may be very good at Title IX. I'm not criticizing anyone, but the universities need to step up and take responsibility and make sure that they have people in place who are trained. And it's not to say that hearing panels or review boards that everyone needs to be a lawyer but everyone needs to have some type of training on Title IX, the nuances, and to have routinely have that training, not just one weekend intensive, but case studies. And we do case studies. We ensure that our hearing boards, they have a guide that they follow. We make sure that the hearing panels and the review boards, that there's fairness and that it's not just one person making the decision. Again, it goes back to that checks and balances.
Oh, so what is actually going on at campuses? So I visited 33 campuses around the country in person, and I get to see a lot of the signs that are up in their dorms. This is a sign that I took a picture of both at Trinity in Texas and at New College of Florida. It's being distributed by New College of Florida. If you have to convince them, it's not consent. And if it's not consent, of course, then it is rape. So I would suggest that most of us in this room, by this standard, are both perpetrators and victims. And
from the married people, sorry.
Yeah. And there seems to be a generational divide where the concepts of coercion and of convincing seem to have conflated, such that any kind of romantic persuasion vitiates consent even of a sober person. I've got some more examples here. This is from a "Where's Your Line? Consent is Sexy" brochure distributed by the Dean of Students Office at the University of Wyoming. This is the image from the front of the flyer. And I'm going to read this out loud because it's just so unbelievable. Anything less than voluntary, sober, enthusiastic, verbal, non-coerced, continual, active, and honest consent is sexual assault.
What does continual mean? Right?
What does honest mean?
How do you know if it's honest?
Right.
And this is a campaign that's aimed
And this is not a liberal campus.
And this is a campaign that's aimed at 18 and 19-year-olds. So these are students who are still developing. Their brains are still developing. They're still trying to find themselves and explore their own sexuality. But universities, by the U.S. Department of Education, require universities to put into place educational programs. And there's not a lot of evidence-based programs out there. And so, various off-the-shelf campaigns universities are taking up and putting out there to their students because it helps them appear to be compliant, but B, again, there's not evidence to back up these campaigns. Whereas the University of New Hampshire, bringing back the bystander, there's actually evidence to show that there is effective bystander intervention that could occur, and that actually decreases the number of sexual assaults on campus. And so there are some evidence-based programs out there, but they're also expensive. So again,
yeah. This is Williams College, and I do have a student who was expelled from Williams College under this rule. They have an affirmative consent rule where to use some euphemisms, my student said, "Hey, how about you do X to me?" And she did X. And then he was like, "Now I want to do it to you." And they participated in that. And she said he never asked me, "Will you do this?" And she never said yes. And this is not all schools have adopted a yes means yes standard. But there are places where the no means no of the 90s, when I was at Bryn Mawr, she never said no. and she participated in all the acts, but said that she didn't actually want to do them, and that she felt physically intimidated by this large athlete who was in her room, and he's expelled. This is at Lehigh University. The Title IX coordinator was quoted in an article, which it's student journalism. We can't be certain that it's been fact checked, but that she participated in the conversation about consensual unwanted sex, and the potential that someone who participated in consensual unwanted sex could go through a formal sexual misconduct case. This is where your partner says yes but is thinking no. That's unwanted consensual sex. So these are very, very difficult. Well, I personally don't feel that I understand these or would know how to have any kind of romantic life if I followed them. And then we're giving this to 18-year-olds, and lo and behold, they're very confused about what the standards are and how they should act.
Just briefly, think about how that would play out at a hearing. Someone comes in, the complainant would come in, probably be upset, testify,
crying,
often while crying, that I really didn't want this, I really didn't want this. What is the respondent supposed to do in that situation? How do you prove, I mean, it's only 50.1% to prove responsibility here. And how do you get out of that? How do you get yourself out of that situation? It can be done, I mean, but it's hard. And think of how terrifying that is. But it's like, but they said yes.
Well, and suppose that your university is on one of these DOE lists of 200 schools that is being investigated for not taking victims seriously. I mean, so prevention, none of us on the panel have training in public health, which is really the area here. But I wanted to point out there's a great article in June 22, 2016 New York Times, which you can get, where Justin's partner is quoted in an article about prevention programs. Probably the gold standard that I've ever seen is a study. It was printed in the New England Journal of Medicine last year, but it is available in full online and is quite understandable by lay people, or at least I think I'm understanding it. And it takes a harm reduction, value neutral approach. So think needle exchanges. You know, we don't get into whether people ought to be shooting heroin. We say, is there a safe way that we can prevent the spread of hepatitis and HIV? Like needle exchange programs, these kinds of interventions can be very politically controversial. But the lead author on that article is Sen. I strongly recommend it. And I think I'd love to see a lot more experimentation along those lines. Okay. So we're going to have a new administration tomorrow. And we might still have a Department of Education. I was a little more worried about that. We have at least a nominee for the Department of Education. Will the Dear Colleague letter be withdrawn? Will some other mandate come out? Will state laws be filling the gap? We're going to hear from somebody a little bit later about that. But I do want to note that there's schools have built up quite an infrastructure around enforcing the law the way it is now, and unless it was all forbidden by mandate, I don't think just withdrawing the Dear Colleague letter would make it go away. I mean, we're talking about the professional organization for Title IX coordinators has like 7,000 members. I mean, they're not just all going to be fired. You know, that there's a whole profession and industry. What are your thoughts?
Well, I mean, for me, the whole industry concept and some of, like the certifications and all of that, I mean, there's no really such thing as a Title IX certification. I mean, that's truly an industry that was built up. I think that with every administration, there are new Dear Colleague letters that come out. It's just part of just going with the flow and following the guidelines of what the Department of Education puts on us. I think that as we started out this program stating that sexual assaults do occur, sexual harassment does happen, and that those are issues that need to be addressed, and they need to be addressed in a fair way. So I don't think that all of a sudden we're not going to have Title IX coordinators, or we're not going to see any prevention programming on campus. That would be my hope that it wouldn't. If there weren't any sexual harassment, if there wasn't any sexual assault, and there was no need for me, I would be totally fine. There's other things I could be doing. But the fact is that they exist. So I don't think that much is going to change, except that it would be great to have some leeway, because the Dear Colleague letters are so strict in certain areas. It would be nice as an institution for us to be able to determine what is best for our students and our community, rather than having that dictated by the Department of Education. Now, I'm not talking about we should allow sexual assaults on campus, but again, the whole idea of like the 60 days and just some of the things that are the specifics that are in that Dear Colleague letter may not be applicable to all universities.
And they could change. I don't think you'll see radical, retrenchment. I think it'll be, maybe they'll change the burden of proof. They'll, settle our case and realize we were right all along. Another thing is mediation. The Dear Colleague letter prohibits mediation in these cases. And I think there were noble goals behind that. The idea that you just sweep it under the rug. Hey, listen, can't we just work this out, kids? We don't want this school to look bad. Do you really want to go through this? So I think it can be bad. But if you think about it, again, as Tanya's talked about, these are, 18 and 19-year-old kids, sexually inexperienced, learning about a complicated, messy, confusing thing often for the first time. And sometimes, would it be better to sit those people down, maybe not in the same room, but just sit down with, whether it's a Title IX coordinator or a counselor, and say, let's talk through this. Like, why are you experiencing this way? And maybe, are you sure you want to go through the disciplinary process on this? Right now, schools cannot do that. They're not, and their hands are tied. So I'm hoping that you'll get a little bit more flexibility, but I don't think it's going to be, all this is going to be swept away. And as Tanya said, it shouldn't be. Good Lord. This is good. This infrastructure is good. It just needs to be, sort of used in the right way.
I think the summary of this is at least Justin and I very strongly believe that students who believe that they can go through an accusation on their own without telling their parents, who are legion, many of them don't want to tell their parents they were having sex at all. Never mind that you're being accused of sexual misconduct, and they say, well, I can wing it. I'm just going to tell the truth, and this is a quasi-judicial proceeding. You need help. Involve your parents and get the judgment of the parents about who else you need to bring in.
I disagree with that, and it's not to say that I believe that students absolutely need support, and universities should offer the confidential support of counselors, of advocates, but I really believe that it's up to the student whether or not they want to bring in their parent rather than encouraging them to do that. There are many times where the students don't have good relationships with their parents, and it's actually been incredibly harmful to have a parent involved. Harmful for the student, not for the university, but harmful for the student. So I think that offering many different resources to the student, and then empowering that student to make those decisions, because that's also part of student development as well, is to empower the student to make those decisions. So a parent could be a support person, but also providing other options for the student.
Yeah, and I think if every Title IX coordinator were Tanya Jachimiak, I think I'd be comfortable with that, but they're not. And so I think, honestly, you get people, my favorite thing that the bad ones do, kid will get an email, have no idea what's going on. He'll get an email, like I've seen this happen a dozen times, get an email at noon from the Title IX coordinator. Johnny, I need you to report to my office at 4:00 today, so I can discuss an urgent matter with you. That's it. No nothing. Kid shows up, has no idea what it's about. It could be something that happened months ago, and I've seen that. All of a sudden says, you've been accused of sexual assault. Here's your no contact order. Now tell me what happened. And they just blindside them. They don't, I know Tanya doesn't do that, but schools do that. And so that's why, I've sort of, like a standard criminal defense attorney, assume everything, the position of like the bad actor. And so if I assume everybody's a bad actor, then I would, in my opinion, in my experience, I guess more, but I don't see as much as Tanya does in some ways. I see sort of the bad. I would say, on balance, making sure your kids tell you. And let me tell you, folks, you all seem like nice people. I'm sure some of you have kids. Your kids could find themselves in this position. I have defended virgins, nerds. It's not all football players. I would say 10% of my clients are athletes. 90% are like kids at Ivy League schools, or whose parents went to Ivy League schools, or who just fancy people who live in nice houses. And like, you don't understand. It's so sad. Every conversation with mom or dad begins, you don't understand Johnny. Like, he's a good kid. And I hear about all the great things he did. And I believe all those things. And I meet Johnny, and those things are all true. Nobody thinks it can happen to their kid, but I'm telling you, like, honestly, if you guys went back to, you guys, and I'll be gendered here, but like, if you went back to college, some of the dumb stuff that you did, you might have found yourselves up on charges. It really, truly can happen to everybody. So if you've got kids in college, just let them know. You know, if you ever find yourself in the crosshairs of this, you have a good relationship, tell me. Like, we'll help you, because I've seen it break bad so often.
Discuss it ahead of time the way you might do with like drunk driving, or at least that was the big movement when I was a teen, was for parents to talk to their kids about drunk driving and say, this is a safe space with you and me. If your driver is drunk, I will come and get you, no questions asked. I'll pay for the cab. That kind of opening the line of communication, which I imagine most abusive parents won't do in the first place, but, and I certainly agree that a 19-year-old who has abusive parents may need to choose some other, guide, but no 18 or 19-year-old that I've ever met in my whole life is ready to understand the consequences of what might happen here. They need a grown-up to explain that to them. And it's not a question of how brilliant they are or how much experience they've had. When you're 19, you cannot understand what it's going to mean to have sexual assault on your transcript. You can't. You need help.
You know, it's also interesting. I know we've been talking a lot about undergraduates, but there's also, these issues come up in professional schools as well, in colleges of medicine, all different types of professional settings as well. So it's not just 18 and 19-year-olds, and I just want to throw that out there.
Sure, that's true. And I'm less concerned about them.
Right,
yeah.
Right.
So that's it. So this is just some contact information for me and Justin. Tanya, as an employee of an organization, I don't know if you have as much freedom to just talk to people about whatever you want, but me and Justin, you can probably get the sense we're telling you 1/8 of what's in our minds, and we want to just ramble and tell you everything else. Call us, email us, and we would love to talk further about this.
Yeah.
So Justin, so we're going to move to questions now. Justin has to catch a flight, so he's going to leave at 7:15.
I have to get back to D.C. before they shut everything down for the inauguration. Oddly, folks, the last flight out of your fine city is at 8:40. I would think it would have been like
at midway.
You think there'd be at 10 o'clock? It's weird. Anyway,
we don't know what it might be.
Last possible flight.
Yeah. But at any rate, we're gonna first do any questions where the questioners specifically want to hear from Justin, and then
maybe none, and that's fine.
Right.
So.
Then we're going to hear a little bit from the Illinois AG's office, and then it's open season.
So I am Julie Palmer. I'm president of Harvard Alumni for Global Women's Empowerment. And on behalf of Harvard Alumni for Global Women's Empowerment, the Harvard Club of Chicago, and the Harvard Law Society of Illinois, I want to, before taking questions, thank our very fine panelists. And I will thank them again at the end of Q&A, but I also want to open this up right away before Justin leaves to questions for Justin. And one technical note for those of you in the room, when you have a question, please pick up the mic in the middle of the table and push the button on the side before speaking. This event, also you should know, is being recorded and being streamed to GlobalWe members across the globe. So so
feel free to use fake names.
Okay, and we're taking online questions as well.
You mentioned this happens not just in college campuses, but professional, but there's also been high-profile cases of boarding schools at the other end of the age spectrum, and I'm wondering if your perspective changes, any of you, but Justin, I want to hear before you left, when it's, a high school student.
Yeah, so just in case that I don't know how the mics work, the question is, does my perspective change at a high school? Absolutely, totally different context. I've actually represented a victim at a high school, and it's fun to be on the other side too, because it's at high schools you really have almost no rights because they're so much more in loco parentis, and it was great. I was basically able to talk to outside counsel and say, hey, you throw him out on his ear, because it was a pretty bbad case. So I think it's totally different. I think you're entitled. I think high schools have so much more leeway, should have so much more leeway. The students are not adults. I think at a public school you should get a little bit of due process. At a private school, people should be fair, but I think it's a completely different analysis when you have a high school, non-adults and stuff like that. Yeah, totally different. And I've never done a defense case at a high school, and I've gotten calls about them, and the calls usually go something like this: I'm super expensive. Depending on your perspective. I'm at Latham, so I'm a bargain. But here's my hourly rate. Your chances of succeeding on the facts you've told me approach zero. Would you like to pay me a bunch of money to accomplish nothing for you? They generally say no, and so that's it. So I generally think it's completely different. My feelings are much more about colleges.
Yeah, I agree that it's very different, although my client experience has been different because I get called by the kids who've been expelled by high school, and they say, can I still go to college? And I say, yes, it's going to be harder. I'm also very expensive, but you won't need a ton of time from me. And I think if you are flexible about where you go, the odds may be quite high that we can find you a great four-year college for next year. But in terms of my expectations of how the schools treat people, they're children.
Yeah.
Other questions in the room, or do we have any online at the moment? Here we go. Thank you.
I think it's the one. I think it's this one. It's on the front with the flash. Yeah, there you go. Yeah.
This question for Tanya. We were talking earlier about the catch-22 for the accused. The talk to the Title IX administrator for exercise his or her Fifth Amendment rights. I'm curious if you, sitting as the administrator, if the accused doesn't talk, do you then draw an adverse inference against them?
No, absolutely not.
Okay. Is there anything does the university kind of have any type of policy, or is that just your independent?
That would be our policy. We do have due process within our policy, even though we're a private institution. But there's still a due process that. And to draw any inferences from that. Plus, it's also the burden of proof is on the individual coming forward. So there would not be any negative inferences drawn from someone who doesn't want to, who doesn't or can't speak to it. And in many cases, if there are criminal charges that are moving forward, I would say 99% of those cases, there's an attorney who's involved, and so we try to coordinate. And my office doesn't. If a report comes into my office, I don't. It's not that I would interfere at all with the police, but our investigations are not tied together. They're very independent.
And do you allow, for example, an attorney or a client who decided not to talk to give you information by an attorney proffer or something of that nature? Consider that attorney process?
It would depend. It would depend. It would depend, yeah. But I just want to go back to that we want to ensure that there's due process. So, for instance, if there's a restraining order against an individual and there's certain geographical limits, and so we can't even have the two parties in the same building or even or they're even though they may not be direct questions, they could be asking questions through third parties. That could be a violation of a restraining order, which then could lead to an arrest warrant and this person in jail. So in those cases, we would require that either one of those parties or their attorney seek to have that restraining order amended or revised so that we could move forward, that wouldn't be a violation. So, I mean, it's a case-by-case basis, but again, my goal is to ensure that there's fairness and due process. I never can assure a particular outcome, but to try to make the process as fair as possible. Nothing's perfect. I'm not perfect. I have not seen a perfect process, but that's my goal.
Real quick, when using the microphone in the middle of your table, if you push the button just once, then there should be a green flashing
and it turns
light.
Green.
And we won't be able to hear it here, but they'll be able to hear it online.
Oh, okay.
So it's flashing green, so it's
And
good.
so I can hear you right now
Okay,
online.
perfect. So you did an amazing job of illuminating this issue, and I, as a public health professional, I was very pleased that you ended that this really is a public health issue. This is a human development issue. And you've also made it pretty clear that there's a lot of gray area, not just in the actual acts or incidents, but in the colleges and the people adjudicating this. I mean, so my question to you is, my question to myself is, why are colleges in this business when there is so much, diversity of approach? And I wonder, my question to you is, do you think that maybe using Title IX as the way to advance this issue is maybe the wrong path?
So I'll answer that just since I feel like I'll give the most counterintuitive answer given what you would think I would say. I think colleges do have a role here. And I think, and it's an important one. I'm not, a lot of people who do what I do say that they should just leave everything to the police. I don't agree with that. I think they have a right to sort of, deal with, and they should sort of deal with things on their campus. I just think they have to do it fairly. Whether Title IX is the best tool, I think that's hard to say. I mean, I think it is. Title IX it's a law, it's a philosophy, it's not implementation. I think how you implement it is sort of where the rubber meets the road. I think that's the challenge. So I think there is a way to do this and do it right through the Title IX process. One idea I've kicked around, and don't steal my op-ed idea that I've been meaning to write for a long time, is what if you outsourced it to, let's say, retired judges on non-renewable 3 to 4 year contracts. Non-renewable, so they don't have no incentive to re-up and, find the right way. And these are people who are experienced fact finders. Maybe not, and you have the university investigate, but then you outsource it to a hearing in front of somebody who's used to weighing evidence, looking at credibility. So I think there are ways for schools to do this through Title IX, but I just think they have to do it better.
I have one online question, and then
We have a first online question from Rebecca Robato. She's not sure if you answered this yet, but she would like to ask what the current definition of sexual assault is that we're using in this conversation.
That is an impossible question to answer, and it varies for each school. But it's a good question. It's just impossible to answer.
So my answer is yes, gray.
Yes, right.
Yeah, absolutely. Yeah. And it goes, and part of that is it goes to varying federal legislation, because the Clery Act has a certain definition, and then there's the state criminal laws have different definitions. Illinois is different from North Carolina. It's different from Minnesota. I mean, so there's so many variations of how it's defined. So,
All right, thank you.
So my question is actually related to that. Because the consequences of having sexual misconduct on your transcript are so serious for higher education, for career, I mean, it changes your life. Do you think there should be national legislation on the definition of what can get sexual misconduct on your transcript? Because I feel that colleges should be able to create the environment they want. They should be able to expel people, but they could expel them for violation of student code or something. Right. But to use that term that's so loaded, do you think there should be a nationally defined, like a statute?
Well, I mean, I would love to see new vocabulary, even innovation in the vocabulary area, even if it started locally, and then if it was widely agreed upon nationally, that'd be great. But, it took us however many hundreds or thousands of years to come up with, what's manslaughter and what's murder and, the kinds of gradations of sin or crime that we have in other areas. Right now, it doesn't exist. So I'd like to see that be invented, and then, I'd love to see it implemented wildly.
I'm a libertarian Republican, so no. I think it should be done locally. I don't want to see anything federal is going to, I think, be paint with too broad a brush.
That actually reminded me, I actually had a student during a educational program I was doing asked me if a husband rapes a wife, if that's still sexual assault, so it just reminded me of sort of the vocabulary and sort of how we even think about rape right now, and how at one point in time that wouldn't be considered
no.
rape. Yeah, exactly.
There was a clear answer.
Right.
I've got to run. Does anybody, if anybody has a question for me, I'm happy to take it. Otherwise, I will thank you all for your attention and be sorry I can't stay.
Let's just give Justin a hand now. Thank you so much, Justin. And I promised our first post Justin's participation question goes to Kara, who is, there you are. Okay.
I'm going to stand up so that I can see everybody.
Need the mic.
Yep, please.
I'm Kara Hendrickson. I'm a law school grad. Does this make me louder?
No, it's
Great.
broadcasting it.
Okay. I'm a law school grad. Thanks for giving me the opportunity to talk. I am the Public Interest Division Chief for Attorney General Lisa Madigan, and I just wanted to have the opportunity to talk a little bit about some of the topics that we've already addressed, that the panel has already addressed, in particular, tools that are available and out there. Title IX is not the only tool. I'm here to tell you that state laws are really relevant and may become increasingly relevant beginning Monday. So let me tell you just a little bit about what's happened in Illinois. And I brought some materials. I won't go on and on, but I brought some materials which I'm happy to distribute to anybody here who would like to have them. So Illinois last year passed the Preventing Sexual Violence in Higher Education Act. It touches on actually a number of areas that were discussed here today. The law came out of a series of symposiums that the Attorney General organized across the state of Illinois, and we invited stakeholders across the spectrum with respect to this issue to attend those symposiums, and we had a number of panel discussions and really tried to get at what are the issues that are out there, where are there problems, where is there confusion, where is there an unmet need. So we had Title IX coordinators, we had folks from colleges and universities across the state of Illinois, we had survivors groups, we had rape crisis counselors, we had folks from across the spectrum get together and talk about the state of campus sexual assault in the state of Illinois. And the Preventing Sexual Violence in Higher Education Act came out of that effort. I'm going to tell you a little bit about what it does, but the important message that I want to leave you with is this law is in effect in the state of Illinois. It went into effect at the end of last year. Our office, along with the Illinois Department of Human Rights, has enforcement responsibility, and there are reporting obligations. So as changes take place on the federal level, there is important state law in place as well. So a couple things that the law does, and some of these are relevant to the conversation we've just had. First of all, it requires every college and university in Illinois to develop a comprehensive policy concerning sexual violence. So we talked a little bit tonight about colleges that are higher profile, that often have more resources. What we found is that in the state of Illinois, not all colleges and universities were prepared to deal with these issues equally. So some of this is just basic baseline. Everybody has to have a policy, and that policy has to be available on the school's website so that people can see what it is. The law requires that schools provide confidential advisors to survivors. So there are resources available for students to help them understand what their rights are. It provides for additional reporting opportunities. Part of the objective here is that schools get information about what's happening on their campuses so that they can make it a safe environment for all their students. So it allows students to report electronically, confidential, anonymously. It provides for bystander or third-party reports as well for schools. It defines consent consent, a minimum level of consent in the state of Illinois. It is not an affirmative consent standard in Illinois. It actually dovetails with our state criminal law, but schools may go beyond that and create a more demanding consent policy. But one of the things that we heard from colleges and universities is we have trouble with basic definitions, and so the state law defines a minimum standard. Survivors have to be notified about their rights. We heard a lot about confusion about what actually the school's policy is. Where can they get medical care? What can they do next? So the schools have to provide that information. It does set out some minimum components for a balanced procedure to resolve complaints. We talked a little bit about that today. These are baseline requirements. So you have to have, for example, the same procedure apply to all students. If you have students who are both in the band, who are the survivor and the accused, you can't have the band director adjudicate the complaint. Same complaint for all students in the university, and there are other components as well. It requires training for students, training for campus employees who adjudicate these complaints, so that you don't have somebody pulled from a part of the staff that is not familiar with what to do in these circumstances. It requires schools to participate in task forces with their communities. One of the concerns we heard about the difficult situation with law enforcement is you have schools who don't even know who in law enforcement to talk to, who to pick up the phone to call. So folks have to talk to each other. And finally, there are reporting requirements. So I have more information about the law. I just appreciate the opportunity to let folks know there is a state law. It is out there, and it's important. So thanks for the opportunity to do that.
Thank you. Thank you. Additional questions?
I guess my question is to Tanya. It involves.
I can't hear you online.
Did you first rebut? Yes, I did.
Is it green?
No, it's.
Did you get it?
Yeah. You can just repeat this one. This one's working. My question has to do with sexual harassment charges and the procedures for faculty members that are accused versus students, and whether faculty members are getting more protection, whether you think the procedure should be the same for, let's say, a faculty person to, so I guess that's my question. Faculty student and faculty. So there's two.
Right. It depends what you mean by, the types of policies, because there are, for instance, at the University of Illinois, faculty members are also unionized, and so it's that policy would be very different than the student policy. I think that the policies need to be that.
Well, at your university, what is the policy for faculty? Like a faculty accusing another person of sexual harassment, another faculty versus and a student accusing a faculty member, what protections do they have?
The student and faculty harassment prevention policy applies anytime the accused individual is a staff or faculty member. It's a very similar process, although it's a review board, but it's very similar, generally speaking. There's some different terminology, but essentially they're the same. In terms of the standard of proof, again, it's preponderance of evidence, which has been handed down by the Department of Education. We ensure that there's confidential resources for both faculty and staff and for students on both not only the accusing party, the complainant or victim, but also the individual who is being accused, to make sure that they also have the support that they need. The definitions of sexual harassment are what are defined by law. Title IX and Title VII are very similar in that manner. Does that answer your question? They're similar. They're not exactly the same.
No, but I guess my question is if I'm a faculty member who's accused by another faculty member or another student of sexual harassment, sexual assault, whatever it is,
right,
versus I'm a student at your school accused, does the faculty member have more protections? Do they have different...
If they're tenured, oh, absolutely.
So if you're tenured,
no, if they're a tenured faculty, right? And there may be, if the person has the status of an instructor, there may be a contract. Again, if a faculty member is unionized, there may be a union contract. So the tenure process. So tenured faculty arguably have more protection in employment than a staff person who's not unionized. And so there would be different protections there. But again, the policies themselves incorporate due process. So there's due process in both policies.
Another online question, please.
I have a question from Reva Mason. She asks, what should Harvard alumni be advocating schools do to have a fair process?
It's a difficult question, and my work with students who are more or less the fallout from poor process doesn't mean that I don't appreciate that the schools are rather in a rock and hard place. But I think that if you're going to do this right, it's going to cost money, and I think having, if not lawyers, at least experienced advocates for both sides immediately is essential to having a fair process. I think particularly when we're talking about college students and those who are younger, and there's a enormous disproportion, at least in my practice, and Tanya, you can tell me if this is true in yours as well, that a huge number of these disputes arise when someone is in their first semester of their freshman year. And are just kind of figuring things out. I would like to see, in addition to all the support for survivors, I'd like to have schools have websites where they say, if you have been accused, here's some steps you can go through. Here's a person you can safely and confidentially talk to at our school as well. And that does not in any way take away from the service and support that's offered to accusers.
Thank you.
I'm just going to ask someone in our audience to weigh in on that question, because we have someone here. I've invited Bruce Melton, who's spent a lot of time thinking about this issue and one approach universities can take, and so maybe you can weigh in. He spent some time thinking about whether this function should be outsourced and how to make it fair.
Yeah, it's interesting because Justin talked about you hand? Yeah. Okay. So he talked about outsourcing adjudication functions to decide. So what I'm looking at is how you do investigations, which is a chronic problem of training, and how you should advocate better process there. It's hard though, because that's actually one of the areas where you have the least amount of control. Right? They come in, they talk to folks, and they get interviews. So it's very difficult when people talk about, like, how can we improve the process? I think you see it. What are the biggest lapses that you see when you're looking at, and I know Justin does the litigation side, but for yourself, when you're looking at students, where are the big potholes that people run into?
Big potholes include, now Justin mentioned the biggest one, which is kind of blindsiding the student and asking them to suddenly, without warning, and often without knowing who has accused them.
Which is ridiculous.
Right. Yeah. Justin was telling me about a case that was even worse than my case, where the student was told, multiple people have accused you. Turn in your response by Tuesday. So that's a very big problem. The lack of subpoena power is sometimes a huge problem where, kids these days, there's usually tons and tons and tons of text records. People have been IMing each other, texting. Especially if it comes up months or years after the incident, you really need special legal power to regain access to those critical evidence about how you discussed it the next day, which is often all on the record. Some kind of, I also see several students who I wish had been warned, where the accusation amounted to, I remember nothing, I must have been raped. And no one told, and the accused student didn't involve wise adults in the process. And that student can't, let me put it this way. The entire case against him was his filling in what happened over the night to this woman who he believed was who was apparently consenting, and the entire case against him consisted of his admissions that they had sex. Even she was together enough to climb the ladder to the bunk bed, etc. But that some equivalent to Miranda warnings, but where people decide what they want to disclose. And in many cases, I've seen apologies used against the accused in very ambiguous contexts. We're not talking about, I'm sorry I raped you, but where your girlfriend or your hookup comes to you at some point in the next few weeks and is really upset. And it's my experience as a married person that it's often a very good idea to just open by saying that you're sorry because the other person is upset. That's plenty. It doesn't mean you think you did anything wrong. It means that you care about this person, they're upset, and you think that maybe apologizing will make them feel better. And then those apologies become the core of a case against usually the young man. And when I'm looking at and sometimes I get to see them because they were in text, and they seem to me ambiguous at best, or really clear good faith attempt to repair the relationship. So those are very frequent problems.
It's interesting. I'll just throw in one other thing we found, and we've been working with an insurance company that does work in higher education. We've looked at many investigations and reports and the process. And one of the things that was interesting to us, and I know this company cares about this issue, and Tanya, this gets to the heart of what you do. The idea that students are not just confused about the actual problem that they had, but about the process and who are their friends and who are not their friends. And we think that one of the hardest things is that they are getting support services from the very people who can turn around and do investigations. And they just don't know. So it's a little bit like the cop comes, but they actually look like a psychologist or a social worker. Those are really hard challenges, and most schools just don't have the bandwidth. Stanford, to a point, counsel, really nice, great for Stanford. But I actually think that can be a real challenge, not just for the students, but for the people providing those services. You have this different role. How do you switch back and forth and feel comfortable about it? So I'd be curious what you think. We think that's a genuine problem that gets people really caught in the switches.
Oh, absolutely. I think it's a problem. There's just a lack of clarity at most schools.
Right, and that's why it's really important to have those confidential resources for both parties or for all parties involved, depending upon the facts. And it's also important to have those checks and balances. So first off, to your point about not necessarily having a decentralized process where individuals who don't have training in investigations are doing the investigations and then making the decisions, but also not having a single person making those decisions. So, for instance, I coordinate the policy and I oversee and I train, but I don't actually make the decisions of whether or not there's a policy violation. So that goes to the checks and balances. So again, I could provide support for both sides equally, not favoring one or the other, for both sides, trying to make sure that they understand the process and that they have those other confidential supports, because I'm not a confidential resource, making sure that they understand that. One of my colleagues and we do a training that's called Stop, Drop, and Roll, and how to respond to disclosures of sexual assault. And the whole idea of stop is that to stop the conversation, to let the person know that we're not confidential, we're private, we're not going to spread it around, and then, sort of to drop those assumptions and roll the individual to this confidential resources so they could explore what the options are before having to move forward and trigger some type of investigation with the university. And it's important that we provide that support and those services for all parties, not just the victim or not just the accused party, but for all.
I'll add that another practice that has come up in a number of my cases is complaints that are filed and pursued by third parties, not by the alleged victim. And in many cases, the alleged victim won't cooperate at all, or even in one case is begging to be a character witness on behalf of the accused. This is someone who was that student was 17 and very much intended to make love to her boyfriend.
It's so harmful. I mean, that is so harmful to, assuming that happened. I mean, it's so harmful to a victim to move forward with the process, and they may not be at that point. And so in terms of healing, it's just
right. And I get where it comes from in the context of domestic violence law, where so many domestic violence victims fear retribution from their abuser, and thus many police departments say if a call comes in, we're arresting somebody, even if you say you changed your mind. And that's probably really good policy in the domestic violence area, and I don't know that it makes sense here. Where there's a lot of, I don't know that there's a widespread problem of people withdrawing accusations because of physical or financial coercion like there is in the domestic violence context.
So in the interest of letting you all out on time, I will end the program now, but I think, would you two be willing to stay? Okay. I think our panelists would be delighted to stay and keep talking for those of you who want to stay. I want to obviously thank Hanna and Tanya and Justin for their giving us their time and their wisdom. We are so pleased and delighted to have you here. Thank you so much. And I want to thank all of you in the room who've made your way here this evening, and those of you who've joined us online. I also want to make sure to thank Corey Crockett of Harvard GlobalWe for her tireless work planning this event and coordinating our technology this evening. And I want to thank Latham and Watkins for hosting us so generously, and Eric for helping with the technology coordination. For Harvard Alumni for Global Women's Empowerment, this is the first of a two-part series, so we hope you will consider joining us for the second part. And we also hope, if you're not already a member of Harvard Alumni for Global Women's Empowerment, that you will consider joining. It's free. You can find us online, harvardglobalwe.org. This event is being recorded, and so you'll be able to watch it again, we hope, online at that same site. And I guess that's everything for this evening. Thank you all very much, and thank you.